Good evening, I'm Mike Marza as we look back at a big day in the trial of Sean Diddy Combs and somewhat of a confusing element to today's proceedings. If you've been following a variety of news today, prosecutors telling a judge they will no longer pursue theories that the hip-hop mogul was involved in attempted arson and attempted kidnapping. Despite the change, Combs is still facing charges of witness tampering, drug and bribery charges, and it's all part of a 5-count indictment which a jury will soon be deciding. So what does it all mean moving forward as jurors get prepared to hear the closing arguments? There's Bernarda Villalona, who we're going to talk to in just a moment, ABC News legal analyst, to figure out exactly what happened today. But first up, Darla Miles with the recap from Lower Manhattan.
A battle behind closed doors all day Wednesday about what to tell jurors when they begin to deliberate on the fate of Sean Combs and the complicated 5-count indictment against him. Judge Arun Subramanian telling the court this afternoon he's received about 200 objections in the legal language for jury instructions. Federal prosecutors surprising many in a letter filed overnight, saying they don't want jurors to consider attempted arson, attempted kidnapping, and aiding and abetting sex trafficking, writing they are no longer planning to proceed on these theories. This, in part, relates to the testimony of former personal assistant Capricorn Clark and singer and musician Kid Cudi. But in order to prove racketeering conspiracy, jurors only need to find Combs guilty of 2 of these alleged underlying crimes: kidnapping, transportation for purposes of prostitution, sex trafficking, bribery, and distributing controlled substances. Over the last 7 weeks, federal prosecutors calling 34 witnesses and laying out sexually explicit texts and videos about the days-long sexual encounters referred to as freak-offs, trying to convince the jury that Combs coerced Cassie Ventura and an ex-girlfriend testifying under the name Jane into participating. But a major part of the case against Combs involved his chief of staff and members of his security team, who prosecutors allege were part of the racketeering conspiracy, but they never testified for the prosecution nor the defense.
Our thanks to Darla Miles. Following everything that happened inside court, joined now by ABC News legal contributor Bernarda Villalona to talk a lot about this. You see these headlines this morning of charges dropped and prosecutors are sort of narrowing down their case and all of this. What exactly happened in court today? Mike,
that's why it's so important for people to get their news from reputable channels and people that are actually inside of the courtroom and have been following the trial. So in terms of what happened today, the prosecution yesterday sent a letter to the judge of their edits to the jury instructions that they're litigating of what's going to be told to the jury. So in terms of a part of their letter, they said that they're no longer seeking the attempted kidnapping and attempted arson and the aiding and abetting of sex trafficking. They did not dismiss any of the counts. Sean Combs is still facing 5 counts, racketeering conspiracy, 2 counts of sex trafficking by force, fraud, or coercion, and 2 counts of transportation to engage in prostitution. So in terms of no longer proceeding the attempted kidnapping or the attempted arson, they're saying no need to because an actual arson transpired. There was an actual kidnapping that happened. There was no attempt to do it. It actually was fulfilled, both of those acts. So yes, they're still going forward. They're still going to be analyzing the kidnapping of Capricorn Clark. They're still going to be analyzing the arson of having to deal with Kid Cudi's car. So nothing has changed except that some of the language of the jury instruction is no longer needed because the prosecution is going with that the act was actually completed. So they're going for all or for nothing.
So it sounds like a lot of legal housekeeping. Which
yes, it's
today
normal.
Was for,
exactly.
Right.
It is normal. With every trial that happens, you streamline the charges because you want to try to simplify the charges as much as you can, especially if you want to simplify. So when the judge ultimately reads the instructions to this jury, it's going to be over 100 pages that's going to be read to them. So if there's no need for unnecessary jargon, it's like, get rid of it.
Yeah, and you think that would take a couple of hours.
Yeah, it's going to take a few hours.
So when we hear the verdict read, we expect still that it will be count 1. Count 2,
absolutely.
Count 3, count 4, count 5, and that's how it's going to play out.
Yes. And just to be clear, when it comes to the racketeering conspiracy, the prosecution is giving this jury 10 options of predicate acts. So 10 predicate acts are going to be listed on the verdict sheet. the jury only has to find him guilty of 2 of those predicate acts.
These are underlying crimes.
Yes,
that
underlying
in conjunction
crimes.
with
Absolutely.
then make the
racketeering conspiracy, exactly. I mean, they have options: kidnapping, arson, bribery, tampering with the witness, forced labor, the sex trafficking, the transportation to engage in prostitution, the possession with intent to distribute. So any 2 of those acts would meet the racketeering conspiracy.
On the eve of closing arguments, what are you doing if you're the prosecution?
Woo! So first off, during the jury charge conference today, the judge actually allowed the attorneys that are going to do the closing arguments to be excused, not be present during these hour-long conference that's taking place right now. So in terms of what is the prosecution doing, what is the defense doing, they are both going over the transcripts, going over the exhibits, going over the demonstratives, going over the charts, going over the jury instruction. Because you got to think, Mike, when it comes to closing argument, this is the last time that these attorneys are going to be able to address this jury and give it all that they got to say how the prosecution has proven their case beyond a reasonable doubt. Because once they take a seat, there's no more talking to them. Now it's up to the judge to give them the instruction and for them to apply the facts to the law to the facts in the case. So in terms of the prosecution, they want to try to streamline their own closing argument as much as possible. Because both sides have already said that it's going to take over 4 hours.
4 hours?
4 hours.
I know this was a 6-week-long trial with 34 witnesses.
I think it's excessive.
But 4 hours?
I honestly think it's excessive. I've tried cases that have lasted over 6, 7 weeks, 8 weeks, and I have not given a 4-hour closing arguments because you lose the jury.
I was going to say, is there a danger in that if you're...
It is.
Yeah, because they're going to get lost in just
and people start tuning out. I mean, people start tuning out. So, yes, the jury is going to be taking notes, but really you need to focus on give them instructions as to once they go inside of that deliberating room, what's the first thing that they should do? What should they focus on? What are the issues? How do you apply the facts, the law to the facts? How do you deal with credibility and believability of the witnesses? Like, how did each witness prove an element or elements or the actual crime itself? And how was it actually corroborated by other witnesses or other evidence? Like, tell them how to do that. That's what the prosecution, that's your job. That's what you need to focus on. Now, the defense has a completely different job. The defense is going to try to poke holes to the jury and list different reasonable doubts that they believe that the evidence has shown or the lack of evidence has shown. So that's the job of the defense, because they also run the gamut that if you're up there too long and you're given so much credibility that you have to be up there so long making these arguments, then it's like, wait, I guess the prosecution did do their job because you're harping so much on all of the witnesses that have testified. But again, in terms of the defense, they just have to plant seeds of reasonable doubt because they don't have a burden of having to prove that Sean Combs is not guilty. They don't have to say anything, in fact, but they are going to point out to this jury, be like, well, can you really believe Cassie, or can you really believe Jane? Do they really have a motive to testify? Actually, a financial motive to testify. So they're going to carry out the same themes that they did during opening statements, that these are consenting adults, that they also have to be accountable for their actions, and also about the inconsistencies throughout their testimony. And because there was inconsistencies, you can not believe what they were testifying to. And also they're going to harp on, like, look, this wasn't no criminal enterprise. This was a business. These were a business that was being carried out, not one that was made for the purpose of engaging in criminal activity. So a lot's going to be said. Mike, doing closing arguments tomorrow and possibly even on Friday. I hope they're wearing comfortable shoes and have their bottle of water ready.
Yeah, and there is something to that, because then after the 4 hours of, likely 4 hours of prosecutions, closing arguments, the 4 hours from the defense, the rebuttal, right?
Yes. So the prosecution gets to close first, and they give like a mini closing argument. And notice that I say closing arguments, which is different than opening statements. In opening, they're only supposed to state to the jury what they expect the evidence to show. They're not supposed to be making arguments. Now, closing arguments, you're making arguments based on the evidence, inferences.
Like so-and-so said this,
exactly,
and this is the receipt.
Exactly.
And,
So in terms of how it's going to go, the prosecution is going to do a mini closing argument first. The defense then gets to do their closing argument, and their closing argument is going to be the full closing argument because once they sit down, they don't get a chance to get back up after the prosecution gives their rebuttal closing argument. And the rebuttal closing argument is more than likely going to be much longer than the initial closing argument given by the first prosecutor. And I believe they're also dividing it where it's going to be one prosecutor for the beginning of closing and another prosecutor, which will probably likely be Maureen Coolney, that does the closing rebuttal.
And if you are the prosecution, what are a few of the strongest points that you feel confident in your case in this closing moment?
Transportation to engage in prostitution, because there's no issue of consent of whether Cassie or Jane or these entertainers or escorts wanted to engage in these sexual activities. That is not a defense at all. As long as you were engaging in sexual activity and you were given something of value for that sexual activity and you were transported across state lines, then you have the transportation to engage in prostitution. And because you have the invoices, you have the various text messages, you have the hotel records, you have the text messages of the communications of arranging these meets with these escorts, and then you have the financial records. I mean, I think I saw a Cash App, payments that were made by cash. I mean, you have so many different variations of payment. That's the easiest one. So I will focus on that. That's the one that's more confident, I think. And I think the defense is going to have a hard job trying to say that the prosecution didn't prove that count. I wouldn't be surprised if the defense just doesn't touch it, just remains mute and doesn't even touch that count.
Well, where is their strongest point to be made?
Their strongest point is having to deal with one of consent when it comes to these sexual acts, because Jane and both Cassie, despite engaging in these sexual acts and saying that now they're saying on the stand that they didn't consent to it, it wasn't their own free will, their text messages say differently. So that's their strongest points for the defense, and also their strongest points, what they're going to be focusing on is that there's no agreement when it comes to who are these co-conspirators, who are these people that were working in this criminal enterprise, and that Sean Combs wasn't out there operating a criminal enterprise, but also the money grab.
Yeah. If you're a juror, you've listened to all this evidence. We haven't heard the closing yet, but you've heard the evidence. How do you vote?
So that's the thing. Right now, you're not supposed to be voting.
Right, because you have to take the full
It
scope
is not
of
until,
everything.
and the judge will tell you, you are not allowed to begin your deliberations or talk to other jurors until I have given you the jury instructions and I tell you you can start deliberating. And once you start deliberating, you can only deliberate when the 12 jurors are together. So if one juror goes to the bathroom, you need to stop, wait for that juror to come back from the bathroom, sit down, because all 12 of you must be together. So I think for a juror, they can have an idea of what they believe, may be guilty, not guilty. But remember, they haven't heard the law.
Right.
So they don't know exactly what crime was committed until you hear the law as it's given by the judge.
Fortunately for us, you do know the law. So as an analyst, I mean, how do you think this case, I mean, what are you leaning towards, knowing everything that you just told us?
Guilty transportation to engage in prostitution. I think the sex trafficking counts are going to be difficult, both for Jane and for Cassie, but especially for Jane, because there's just so many issues as to her text messages and how she came off on the stand that she just wanted to please her lover. And you really weren't hearing that she did not want to participate or that she was being forced to participate in these sexual acts. She was saying, like, look, I was doing it because I wanted to please him and I didn't want to upset him. I just wanted to satisfy him. Cassie is different because you have the violence portion to it. And as we all have seen, is that video from the Intercontinental Hotel. And I have to say that we wouldn't be here today if that video did not make it to lights. So it changes things. Now, the racketeering conspiracy, I think it's a toss-up. as to whether he'll be found guilty on that. And the reason why is that if you read the law, yes, he should be found guilty, but I think it's all going to depend on how the prosecutor and the defense attorneys do in their summations, because it's like, can you land a plane through your closing arguments? Because it's so complex to be able to analyze it and figure out how racketeering conspiracy works. That's why I think it's going to rise and fall in closing arguments.
Last question. Do we think, I mean, is there a correlation? I know there are always those outliers, but if a trial is 6 weeks, a jury deliberates X number of hours, like, do we have any sort of idea of how long they're going to be in there talking?
No idea at all. What I'm looking for, and I'm eager to read and know, is the first note that they sent out. Because those first few notes are going to give us some kind of insight as to what they're looking at, what they're focusing on, or what issues they may have. So in terms of the jury deliberations, if the jury has a note, they fill out a paper, they'll write down whether it's juror number 1, 2, or whatever it is. The fourth person has to sign it. The fourth person has to sign every note. That note is given to the deputy. The deputy gives that note to the judge. The judge summons the parties to come into the courtroom. He reads the note on the record and also shows it to both sides, the note, and then they decide how to address that note. So you just don't know. You just don't know. You're dealing with 12 human beings that don't know each other, that have been put together to reach a unanimous decision. And also you're dealing with 12 human beings that don't know any of the witnesses that testified or have a close relationship with them. So literally you're analyzing the credibility of these witnesses from scratch.
And there's so much at stake.
And it's so much at stake. But the judge tells them that they are not to consider punishment as part of their deliberations. They are not also to consider emotions should not play a role in your deliberations.
All right, we'll see how it plays out. But likely into next week.
Into next week, yeah.
Bernarda, always great to get your perspective. Thanks so much. Stay with Eyewitness News at ABC7NY for all the new updates. We do have a real-time blog, so any update we get, you can get in real time at ABC7NY.